Thank you. Welcome. This is now the 5th installment of the JEWdicial series. I can't believe that it's been 5 months that we've been doing this, and essentially since we conceptualized this idea. For those of you that don't know, this series is conceptualized and put on in honor of my father, Charles Cohen, who unfortunately and suddenly passed away on April 2nd of this year. We've decided to do a series of 11 lectures that coincides with the period of mourning for a son as myself. So I appreciate everybody being here to support my efforts in that as well. We've got a wonderful lecture tonight, and we've had 4 other wonderful lectures as well. But one that's coming up we're very excited with as well is Rabbi Ken Spiro, who is going to be here on November 8th. So please mark your calendars for that. But I'd like to take just a quick opportunity to thank a number of individuals that this would not be possible without. This certainly would not be possible without Chaim Fink with Partners Detroit. This wouldn't be possible without my cousins Scott Cohen and Prime 10. And it also wouldn't be possible without my uncle and my father's brother, Alan Cohen, who lives in Jerusalem and calls Yerushalayim his home, for providing us with funding so we can have this wonderful food that's being provided to us by Prime 10. At this time, I'd like to turn it over to Chaim Fink to introduce our speakers for tonight's program.
Thank you, Andy. Thank you very much. All right, good evening, everyone, ladies and gentlemen. I am particularly excited about tonight's lecture because really the concept of this series is to take cases where the Torah, where the Talmud has one point of view, and the American legal system perhaps has an agreeing or disagreeing point of view, and to show you that contrast. And I think tonight we are going to do a great job of that. There are 2 presenters. I'm going to start with my colleague, Rabbi Leiby Burnham. And Rabbi Leiby works with Partners Detroit. That's the organization that I work for as well. I've gone to Israel with him. I've gone to Poland with him. I've gone to Russia with him. We've gone around the world seeing different places of Jewish interest. And to see how he takes the ancient wisdom of the Torah and makes it relevant to 2017, so relatable, things that you really just apply to your life. He's creative that way. He's an incredible writer, phenomenal orator, and it's really an honor to stand alongside him in helping with the work that he does. So we're very excited to hear from you tonight, Leiby. Now, Gary August, I met when I first came to Detroit. Gary is an excellent lawyer, has litigated on some of the biggest cases. The McNamara Terminal was his baby. That was his project. And I could read you his resume, but that won't give you a clear picture of who he is. I know that Gary is a connoisseur of some excellent vegetarian cuisine, if I'm not mistaken.
Eating at your home.
Gary and I have spent Shabbat dinners together, so that's a beautiful shared experience. But I've seen him as a father. I've seen him driving his kids deep into Canada because he wasn't yet comfortable with their skill level at driving that distance. Just a year or 2 they'll be able to drive on their own. But to see him as a doting father, a loving husband, that's the person of who he is. A charitable individual, someone who's a community person who cares about the community and the Jewish people. We're honored to hear from you tonight. Thank you both.
Okay, so alrighty, I'm going to open just because the Jewish law has about a 2,700-year legal precedence over the American law. So I'll start first, and it's a little intimidating, obviously, going up against Gary August here. I know Phil Arbit told me he's got my back. He's rooting for me.
And it's intimidating being on the same stage as Leiby, and after you hear tonight's presentation, you'll understand why. But go ahead.
Thank you. So what we're going to try to do, just in terms of layout for tonight's presentation, is going to be very different than the previous JEWdicial series, if you've been here before, because we're really going to be presenting how Jewish law works under the framework of American law, or American law works under the framework of Jewish law. And what we're going to do is we're going to present 3 different cases. One case in Jewish law which really worked the way it was supposed to work, despite its outcome being slightly different than it might have been in American law. One case in which Jewish law did not work. And one case which is sort of still to be determined, and that's what we'll be talking about the most tonight. So, to start off my presentation, or our presentation, I want to just point you to your source sheets, because before we get into Jewish case law, we have to understand the imperative of Jewish law. So if you look at your source sheet, in source number 1, it's a verse from the book of Exodus, in Parshat Mishpatim. It says, Eila ha-mishpatim asher tasim lifnehem. These are the statutes that you shall place before them. And Rashi, as you can see in source number 2, comments, before them, you place these laws before them, and not before the courts of Gentiles. And even if you know, says Rashi, in a particular law that the Jews and the Gentiles rule the same way, you are not allowed to bring it to a Jewish court of law. Because if you do so, continues Rashi, it's a desecration of God's name. It's like saying his system, his legal system that God devised and put forth to us in the Torah is not as good as the American system or the British system, wherever you are in the world. Therefore, by Jewish law, if you have a problem, a legal issue with another Jew, you are absolutely required to bring it to a Jewish court of law known as a Beth Din or a Beis Din. Let's see this in the Jewish law. So now we go to source number 3, which is the Shulchan Aruch, the Jewish code of law. Choshen Mishpat, which is the section of the Jewish code of law that deals primarily with civil law, torts, and partnerships, etc., etc. And here's the source. It's Choshen Mishpat, chapter 26, Halacha 1. It is forbidden to judge cases before Gentile judges and Gentile courts, even in matters where they rule like Jewish law. And even if both parties agree to follow the non-Jewish rules, they say, listen, I know that I'm supposed to go to Jewish law, but we both had agreed that we'll just go to a secular court. It's still forbidden. Now what happens if one litigant says, I'm not going? And we'll get into that in more detail later, but it just says the law here is if the non-Jews have power over the Jews, like they have been for the last 2,000 years, where we've been living in exile, and his opponent is a rough person, a person who's not going to listen to the dictates of Beis Din, then, and a person has no other way to save his money, what he does is he goes to the Jewish court of law. The Jewish court of law issues a summons to the person once, twice, 3 times, or if his response to the first one is blatant disregard, even only 1, and then the Jewish court of law will give another Jew permission, written permission, you can take this to the secular court of law, because this person is clearly not willing to take it to the Jewish court of law, and then you go to the secular court. All right, so that's sort of the imperative. And again, from a philosophical perspective, the idea is that we show honor to God by using his system over the secular system around us.
I'm going to just insert one thing at this point, just because I want to say something. But I assume that there's a lot of lawyers in the room here because of the relationship with the Jewish Bar Association of Michigan. And how many times have we written or looked at an agreement that says at the end of it, this agreement shall be interpreted under the laws of the state of Michigan, and any disputes under this agreement need to be resolved in a court of competent jurisdiction within the state of Michigan. Sometimes they may even say within Oakland County or the county of Wayne. I have drafted hundreds of clauses that say that, and I have seen hundreds, if not thousands, of contracts that say that. What Leiby is saying through the Jewish law, that is an illegal term under the Jewish law if your contracting partner is another Jew, all right? Then, and if the other Jew tries to enforce that provision to get out of the Beis Din by saying, but we agreed to this written contract that any dispute would be settled by a Michigan court under Michigan law, that term would become not only unenforceable, but an insult to God that you have chosen to put that term in your contract. And I find it so surprising given the number of contracts between Jews that actually have that term in it.
Even if they're not Shomer Shabbos?
Yep. Yeah, this is Jewish law. So Jewish law doesn't differentiate between whether someone is Shomer Shabbos or not. Jewish law doesn't, it's not like you open up the Jewish code of law and says, these are the laws for Jews who are Reform or Conservative or Orthodox. This is Jewish law. It applies to everybody equally. Of course, not everyone follows all of Jewish law, just like not every Jew eats kosher, although kosher is Jewish law for everybody. Not everybody follows Jewish law. And the next case that Gary's going to present, and I'll present the first case where Jewish law worked perfectly, and then we'll talk about a case where it didn't work, and we'll see how it really kind of plays out in the real world.
How do you reconcile that with the principle of Dina de Malchus Dina when it comes to financial matters, the law of the country you're in?
Right. So the Dina de Malchus Dina has to do with, so what's being asked right now is there's a law called the rule of the law, the rule of the land is the rule. But that applies to matters like speeding or the IRS. And the rule of law of the land does not say that you are required to create a contract that says it's going to go through Michigan. Gary might write that in all of his contracts or many of his contracts, but it's not required. You can also write a clause that says that when there'll be disputes, it will go in front of a Beis Din, which we're going to hear about tonight, a contract such as that. So the law of the land is that you can't speed, that you have to pay your taxes, right? Et cetera, et cetera. The law of the land does not say that you are required to write your contracts in a way that they'll be taken to Michigan state law.
So if there's a conflict in financial matters, talk financial, between, let's say something you see in Kosher Mishpat and something you see under Michigan state law.
Yep. So if you go, you are required to take it to a Jewish court.
Including criminal.
You're required to take it to a Jewish court, and they are required to rule according to Jewish law. Correct.
But I have read that there's situations where there is an established principles and courses of dealing between, like, for example, merchants, where you follow the Uniform Commercial Code, and there's things about acceptance and shipping, that the Beis Din will consider those in making its determination of what is fair and equitable, but it's not bound by those. Unlike the secular courts where it's bound to follow the law of the land, that will be something that the judges in a Beis Din will consider as part of it. But the law that they have to apply is the Jewish law, because that's the law of God.
Alrighty. So let's give an example of where the Jewish law worked out really well. So when I was probably about 19 years old, or maybe 18 years old, I was living alone in New York. My parents lived in Israel. So when I got my first car, I had to insure it myself. Now, of course, when you're insuring a car as a 19-year-old or an 18-year-old, there's something called the high-risk pool in New York State, where your insurance premiums are a fortune, and then if you earn through good behavior your way out of that, then you get out of the high-risk pool, and your insurance premiums go down dramatically. So I had started off, my insurance premiums were in the 6,000s or so. Then through good behavior, I got them all the way down. My insurance was around $1,200, $1,300 a year. And then I got into an accident. But they can't just kick you off because you got into an accident. Once you've earned your way into a lower premium, they have to keep you, they can step you up a little bit, but they can't just kick you back into the high-risk pool. Unless your insurance defaults and you don't pay your premiums, and then they kick you off altogether, and then you can't get back in. Now, I had an insurance broker, an independent insurance agent, a Jewish guy, and he was the guy I was buying my insurance through. And I get a call in the middle of August one year from the insurance broker saying, you know, you haven't paid your premiums, and if you don't pay, you're going to lapse and you're going to lose your insurance coverage. I said, wow, thank you so much for calling me. Can I pay you right now? I'll give you my credit card right now. Can I pay you? And he said, sure. I gave him my credit card number, and on that day, as the records showed, he charged my credit card and he took the money. I get a letter a few weeks later, or a few days later, whatever it was, I lost my insurance. I called him up. I said, how did I lose my insurance? I paid you on Thursday. My insurance premium renewal was required by Monday. And he says, let me check the records. And he gets back to me. He said, oh my gosh, I'm so sorry. We messed up somehow. We forgot. I said, you messed up. You forgot. Let's see what the renewal costs. He goes into the system. Of course, by now I've had an accident. He says, oh, I'm so sorry. You're back on the high-risk pool. Instead of $1,300, $1,400, it's going to be about $6,200. I said, I'm sorry for you because that's your liability. You messed up. I gave you the money. You're my agent. And you now are required to compensate me for the losses that I'm incurring because of your negligence. And especially being that you're being paid as my agent. So he says, look, I'm really sorry, but mistakes happen. I don't owe you any money. So we got into a heated conversation about it. And finally I said, all right, I'm taking you to court. And he said, okay. So I said, which Bezdin would you like to use? And he pointed me to a Bezdin in New York. I was okay with any Bezdin. It wasn't like this is a multi-million-dollar case. There is a form for choosing a Bezdin in higher net worth cases. So we go to a Jewish court. And we meet before the court. He's a very affable man. I'm a friendly guy. We say hello to each other. It's very, very amicable. We both agree, listen, this is the best thing. Because I don't want you to pay me money if I don't deserve it. Because if you end up, let's say you end up paying me money and I don't deserve it, when I get to heaven, I've got to answer for that. I morally was negligent by taking your money if I didn't deserve it. And you, of course, you don't want to wrong me. If you owe me the money, you want to pay me. Because you don't want to go up to heaven with a debt that you owe somebody you kind of stole from me by not paying me what you owed me. And we both agreed, we go to court. We sit through the court, I lose the case.
Why?
So, why? Good question.
That's what I said, because
ahead, tell us.
under secular law, first of all, Leiby told me this and explained it, and I laid out, okay, was it an independent agent? Was the agent an agent for the insured or the insurer? Okay, and I explained to him, if it was the agent for the insurer, then him accepting the money would have hooked the insurer on to the liability, okay? Because he was the agent for the insurer. But it's an independent agent, okay? Which means it was Leiby's agent, not the insurance company. So the insurance company is out. Now we need to focus on whose fault it was. Was it the insured? Was it the agent's fault? Was it Leiby's fault? I take the position, and I don't know what New York law is, but I have a good sense of Michigan law, okay, that the agent, which was Leiby's agent, was entrusted with the funds and the premium, and he had the obligation to give that to the insurance agent. If he failed in that obligation, he will have breached a duty to Mr. Burnham, and sure enough, he would be held liable, and I'd say go get it from your E&O carrier, your errors and omissions carrier, which would be the insurance agent for the agency as opposed to the car company. So when you laid this out to me, I said, under secular law, he breached a duty to you and should be responsible.
Was this a Burnham Garmi type of thing?
Yes, actually exactly right, by the way. So under Jewish law, this is something called Garmi. Which Garmi means is that it's an indirect cause. Meaning, he didn't directly inflict financial damage on me. He did something, he was negligent, and through his negligence, financial harm was caused to me, but since it wasn't directly inflicted by him, he was off the hook. So we left the court, and I shook his hand. I said it was a pleasure doing this. I really felt glad, because like I said before, I would not want to take someone's money if it wasn't owed to me, and if this is how Jewish law is, I 100% accepted it. We left as friends. So that's a perfect example of how the Jewish court should work. Ideally, two Jews, both concerned with getting the Torah law. We both went to court. We both agreed beforehand that we would honor the dictates of the court, and it's exactly what happened. Okay.
Would it be
And
a
I-
much time if he paid you?
No, he has no obligation to pay me. The Jewish court said he doesn't have to pay me. Now, if he wanted to do what's called midat chasidut, if he wanted to go beyond the letter of the law and pay me, I certainly would have accepted it, especially when I was 19 years old and $5,000 is a lot of money. But he was not required to.
And if Leiby had taken it to secular court, he didn't like that decision, took it to secular court, and got a judgment against him on my theory for lawyers in there. I say, this is Paul's graph, man. It's totally foreseeable that if you don't pay this premium, he's going to get thrown back into the high-risk pool. That's a foreseeable damage. He should be compensated. If Leiby were to have done that under Jewish law, and he forced the guy to pay him, he would be the one who sinned and would be stealing that person's money.
Exactly right. Okay, let's do one more question, and we're going to move to the next case.
Okay, so Gary made an interesting point. Obviously, in this particular case, it didn't apply, but if your insurance broker had an E&O carrier, had his own insurance, so are you saying and the title of your lawsuit might have to name this Jew, but the defense of the lawsuit and the payment of any damages would be by the insurance, are you still saying that it would, halacha would require to bring that to Bezdin?
That's an interesting question, right? Because I'm not allowed to take another Jew to court. I wouldn't be allowed to take his E&O carrier to court. First of all, I don't know if he had an E&O policy.
No.
Right. I don't know if he had an E&O policy.
But I can try to answer that.
Okay.
I'll do it quickly, okay? First of all, you wouldn't have a direct claim against the E&O carrier because you're not a named insured, okay? So you have no policy provision with them,
But
okay?
that's
So
better.
no privity. But the issue then becomes, you still need to, the E&O carrier has a duty to indemnify its insured, okay? So in order for the indemnity obligation to pay to come in, you would need to have the claim against the insured. And you can't bring that claim against the insured, okay?
Maybe knowing no matter what, it's not gonna come out of his pocket, maybe you can.
That,
Mr.
again,
Aldenstein had a very similar case.
We got to move on to the next one if it's possible. I said one more question.
But I will just add one thing,
Sorry.
and
Yeah.
I'm sorry,
Go right ahead.
this is a problem when you have two people. Okay, the Bezdin have also faced the issue, well, what if I sell my claim to a non-Jew? Okay?
Assignment.
Because I can assign my claim, so I have a claim against his agent for $5,000. I'll sell it to a Gentile for $3,000, okay? And have the Gentile bring the claim in my name. Do you want to address that, or should I?
No, you could, if you know, I don't even know.
Okay.
Okay. Go ahead, by all means. He's both the attorney and the rabbi today.
The research that I have done has said that that is frowned upon and that is not acceptable, okay? But I haven't seen it written in commentary that that's to do that, but people who have opined on it say that me getting that $3,000, while I'm not getting it from another Jew, it's based on that suit that's going through the secular court, and it would still be seen as stealing in the eyes of God, because it would be my claim that was pursued. But that's not universally accepted, but that's a way people have thought to get around it by assigning the claims. Back to you.
Okay, so now that's actually, I'm actually going to shift it right back to Gary right now, because so that was the first case, the case of where the Bezdin worked as it's supposed to work. In order for that to happen, you really need both people in the suit to agree to Jewish law, to respect Jewish law. In America, Jewish law has no teeth. Therefore, if there is not a universal respect amongst all parties for Jewish law, then Jewish law cannot operate, and that is the case that Gary's going to tell us about.
So I had a client who was buying a very substantial piece of real estate in the city of Detroit. And they had in their agreement a clause that by X date, they had to have the lender, the existing lender on the property, okay, by X date, they had to get the lender to agree to an assignment of the mortgage from the current owner to them. So the property's encumbered by a mortgage with a lender. My client had to have communications with the seller's lender and get that transfer by a certain date. My client claims they got that transfer by a certain date, that based on a series of correspondence and all issue, they had lender's consent. Seller says, no, you didn't have lender's consent. You still had this issue outstanding and that issue, and while the lender, you believe that what the lender said in its letter was consent, we don't read that letter that way. We don't believe you actually got the lender's consent until a month later. Therefore, we're voiding the purchase agreement, and the implied threat is we're going to sell it to someone else for more. All right? Orthodox Jews on both sides of the deal. So my client goes and asks them to participate in the Bezdin. Okay, what, a halacha? Is that what's a?
Hazmana.
Hazmana.
is a summons.
Okay.
A summons from a Jewish Bezdin.
Okay, but this was the request. First he requested, will you have your case heard? He was initially told no, so at that point, he was allowed to bring the case in secular court, hires me, I bring the case. For people who know tax stuff, there's something called a 1031 exchange, where if you sell property, you have a certain amount of time to be able to take the proceeds of that property and invest it in another property before it's a taxable event that you have to pay tax on. So that time was running for my client for his 1031 exchange. He had to get this deal done and sold, or he was gonna have to pay tax on the money of his last sale. So we filed the lawsuit. Then the guy who originally said, no, I'm not gonna do it, says, okay, I will go to the Beis Din. Okay, but now time is running. So he's built in delay. And they get to the Beis Din, and the Beis Din, the rabbis don't want to initially rule. They want to try to mediate the case and get it together and everything. And they were going to set a schedule that was going to go out beyond the time for my guy's 1031 exchange. So my person was so concerned that even if he got the ruling from the Beis Din, it may come after he already blew his 1031 exchange, but more importantly, he was concerned that the person on the other side wouldn't honor the ruling of the Beis Din, okay? Because it has no teeth. So my client would say, it's binding on the other side, but it's only binding in his heart. And he believed that this guy had shown, while normally this guy would get benefit of the doubt, he believed that this guy's prior conduct in taking this position with respect to the sale and other things that occurred in the transaction, okay, that this person was not honorable and wouldn't honor the ruling of the Beis Din. So he ended up negotiating a resolution where he paid more. The guy jacked up the price a little bit on him, and he paid more, and he got the property, but his experience through the Beis Din and the law was not positive. He believed that justice wasn't done because he was forced to pay more money when he was right, out of fear that it wouldn't be enforceable in the court.
Can I ask a quick question?
Yeah.
Is there a document that could be signed that would force him to abide by the ruling of the Beis Din?
Yes, okay.
So why not just sign?
Because
that?
they were fighting about the document. That was the very first day they get to the Beis Din, they're fighting about what we would call an agreement to arbitrate, okay?
What we would call, by the way, a shtar berurin. A shtar berurin is a document of clarification that basically states that these two parties are coming before this court to negotiate this conflict and that the settlement will be binding.
And my guy was concerned that even if he signed that, okay, and ultimately it could have been determined in the court and this guy would be responsible, the relief that he would have gotten would have been to honor the original purchase agreement, right? But he would have lost his 1031, all right? And he believed that this guy, maybe if he lost and it went to the secular court, he'd end up, the other guy, how's the other guy hurt? He's getting the property for this very price that he agreed to, okay? And if the court told him he had to agree to that, okay, so I'll sell it to you for that price, all right? But in the meantime, my client was out multi-million dollars in taxes on his 1031.
Why isn't that Dina Demolis Dina? Because there's a secular law about the taxes that have to be, doesn't that, maybe that could trump or something?
So the secular law about the taxes has got nothing to do with whether or not this agreement was fulfilled or not. There's a side factor that will trigger something else, like a waterfall. But right now we're dealing with, did he honor his responsibilities in the contract or not? That's totally covered by Jewish law. The 1030, the tax law that's going to be related to that is not part of the Jewish law, but it doesn't have to be. Okay, go ahead, David.
You mentioned the first point. I know you're a commercial lawyer, but the criminal law, people who read the New York Times, God forbid, you have all the child molestation and people refusing to bring charges, and I think even in Far Rockaway there was a murder case, like God forbid you're the only witness and your fellow Jew, he did it, but it's like, no, I can't turn my fellow Jew over, even if it's, he's guilty of murder.
So I can only tell you what I've heard, and I've heard this from the greatest rabbis in America today that have said unequivocally that if there's a case of child molestation or domestic violence, you absolutely must go to the authorities. So that's the ruling. There are people who don't listen to that. I'm sure there are people who don't listen to it in every area of American life, right? Unfortunately, there are people covering for other people's misdeeds in a whole slew of areas, as we just found out from the Harvey Weinstein case. So there's things going all across America where people are covering for other people. However, by the greatest rabbis in America today, including Rav Shmuel Kamenetsky, Rav Melchiel Cutler, when there is child molestation or domestic violence, you do go to the authorities. Yes, Jeremy.
My question is, all these things that we're talking about, how do we bring in the fact that people enter into a contract normally, there's an assumption that either they know what they're doing, that the contract explains it, or they're expected to hire an attorney to explain it to them, or waive that right. So what happens if you have two Jews who enter into a contract and maybe one knows the halacha and one doesn't? Is there, if it were to go to the Beis Din, would they say, well, you entered this agreement, but you knew what was gonna happen if you came to a Beis Din and he didn't?
Yeah, so there's, I think this would be both in American law. I don't know. I can speak for Jewish law. You got to wear your big boy pants, right? Meaning, if you're signing an agreement, you're bound by that agreement. And if you didn't necessarily know the Jewish law regarding that,
So it's like a secular Jew wouldn't even necessarily think about this. So if a secular Jew does business with an Orthodox Jew, and then the Orthodox Jew, we should go to a Beis Din, you're like, oh, I'm a Jew, okay, sure. And you're like, I didn't know any of this. I would have written the contract differently. Or what do I know from halacha?
right?
You know,
so-
it's consist, in secular law, there's the concept of you can't have a contract that's void against public policy, right? So if I have a contract that requires you to kill someone, and you don't kill that person, I can't sue you for specific performance or damages because you didn't follow through by killing that person, okay? The law with respect to the Beis Din is that serious, okay? If you have a contract that says you have to bring your disputes to the secular court and not the Beis Din, that's void against public policy.
That's not my question.
Okay, sorry, I think I missed it then.
Okay, so in terms of you're going to say people didn't know. There's a certain requirement. Judaism in general expects people to educate themselves and to learn what Judaism requires of us. So, the same question you could say, what about a person who grows up in Kansas, in some, forgotten corner of Kansas, doesn't know that he's Jewish, and he's violating all kinds of Jewish law. He's eating on Yom Kippur, and he's all, that's right. So there's a certain responsibility to find out who you are and what the laws that are relevant to you are. So that would apply here as well. Okay, so that covers a second. One more.
What's your responsibility as a secular Jewish attorney in accepting a case?
There, okay. And this is why, when I did my research and found out that I had drafted hundreds of documents that say all disputes shall be resolved in a state court in Michigan, I can't do that, okay? And as a lawyer, I can't sue on behalf of my client another Jew in a secular court.
Unless they have a permission from the
Unless you have the permission from the Beis Din. It applies to attorneys. Now, we had a speaker, Chaim, help me, the lawyer from Philadelphia, what was his name?
Harry Rothenberg.
Okay, speak at one of these a couple of sessions ago, and he discussed that specific issue. And he discussed that any time that there was a Jew involved, he would have to go and talk to his rabbi. And I believe he even addressed the situation of suing the Jew to get at the insurance proceeds. And he had to get explicit, if I remember right, explicit documentation that that Jew wouldn't be paid, be responsible for anything. And his rabbi said, okay, but yes, it's supposed to apply to legal counsel as well.
And by the way, because of that, after this whole research that we've both been doing, Gary has decided not to do those cases anymore, and he's going to be spending a lot more time doing pro bono work for the American Legal Fund.
Actually, what we decided was I was going to become a rabbi and he was going to become a lawyer.
Okay, and we have one more big case, and I want to be able to cover it. Okay, so there we go. We've got a case where Beis Din worked perfectly. We're a case where you see the failure of Beis Din because Beis Din in America today does not have teeth, and Gary's client was out millions of dollars or whatever it was, a large sum of money, because he was afraid that his opponent was not going to respect the Jewish Bezdin's law, and therefore, knowing that they have no teeth, he had to forego a significant sum of money. And now we come to the third case, which is a fascinating hybrid, and I'm going to have Gary introduce that case as well.
You're going to try to stay with me because the facts of this are very confusing, and if you're not understanding them, I'm not saying them right. So I'm going to try to get it out, and if you don't get it, I'll try to explain. My client and the other side, I'm going to simplify it a little bit, are partners in a real estate company, okay? And I'm simplifying the facts. My client is a minority member of a limited liability company. So let's say my client owns 33% of the limited liability company, and the other side, through himself and people that he controls, owns 66% of the limited liability company. And the operating agreement of the limited liability company says the manager is appointed by a majority of the members, and the manager is, as appointed by the majority of members, now the other person who owns 66%. He has appointed himself manager of the company, all right? And the agreement says the manager has the authority to sell the assets of the company if he gets a majority of the members' approval, okay? So the agreement says he's allowed to sell the real estate, okay? Because he owns 66% or can get the 66% from the other people, okay? But the contract also has a Bezdin clause. And this contract says, unlike the one that I told you about that says any disputes have to be decided under Michigan law in a Michigan court, this one, because it's Orthodox Jews on both sides, says any dispute regarding this agreement shall be resolved in a Bezdin, okay? And the Bezdin in Muncie, New York will decide what Bezdin will hear the case if the parties can't agree on which Bezdin will hear the case, all right? And whatever the decision is of the Bezdin will be able to be enforced in a secular court, okay? But first you gotta have the Bezdin will decide, all right? Now, my client has an interest in the real estate, but on this property is a business, all right? And the business is failing. So the business goes to borrow money from someone. The person who lends the business the money is my 66% guy, okay? No, the 66%, okay? So the lender for the operating company is the 66% guy, all right? So the lender, so the business is going, and the lender sues, okay, the operator because he's not paying the loan. And the court appoints a receiver. And the receiver goes to sell the property. And I'm throwing just round numbers at you. But he's going to sell the property for $10 million, okay? But he's selling the business and the real property, okay? The receiver. Now, the receiver doesn't own the real property. He can't sell it. The only person who can sell it is Mr. 66%, okay? But Mr. 66% is trying to get the money from the operator. So he reaches a deal with the receiver that says, we'll value the real estate at $3 million and the business at $7 million, okay? And my guy says, wait. This business is only worth $4 million. The real estate is worth $6 million, all right? And the reason you're creating it to be 7 and 3 is so that you get all the money because you own the 7, and I get screwed because I've only got the 3 million. So what I'm going to do is I'm going to demand that you sell the real estate to me as your partner. And under Jewish law, if I give you a offer, there's a right of first refusal, which Leiby's going to go and explain. You're obligated to sell it to me, okay? But Mr. 66% didn't want to sell it to him, so they were going to go to the Beis Din. Now, here's the question, all right?
Should we first?
Yeah, go through.
Let's go through the
Did
Jewish
everyone
law.
kind of understand that?
It's a pretty
Okay.
intense case, right? Okay, let's go through the Jewish law in terms of how partnerships dissolve or how partnerships sell their shares. Okay, so I'm going to source 4 over here, which is the Aruch HaShulchan. The Aruch HaShulchan was a book written on the Jewish Code of Law, and it was written in the late 1800s. And I'm using it first here because it gives a little bit of the reason of why we have the rules of neighbors and partners. Okay, so by biblical law, if I want to sell my property, I can sell it to whoever I want, no matter what, no holds barred. However, as we'll see here, the rabbis added a new level. It is a mitzvah of the sages. Again, it's not a biblical law, so it's a rabbinical law that when one sells a field, house, store, etc., that if the neighbor wishes to buy it for the same price that other buyers are offering, he gets first rights to it. Why? The sages explain, there's a verse in the Torah in Deuteronomy that says, V'asisa hatov v'hayashar be'enei Hashem, and you shall do that which is good and righteous in the eyes of God. Which the sages said, well, what is good and righteous? What's good and righteous is if you own a property and you're getting the same amount of money for it either way, but somebody else will get tremendous benefit because he's a neighbor and he'll have adjacent properties now, which will make it a lot easier for him to manage or to live or whatever it is, that it will be good and righteous for you to give it to him at the same exact price you'll get it from anybody else. Good and righteous. Therefore, there's a rule called Dina de Bar Metzra, which means the rule of neighbors. If I sell my house, the first people I got to check with is my neighbors and make sure they don't want to buy it. If they're willing to buy it, I have to sell it to them, so much so that if I don't sell it to them and I sell it to somebody else and the price goes up, halachically, my neighbor can sue me and they can void my sale. Again, in Jewish court of law, they can void my sale because I did not follow Jewish law, and it goes back to my neighbor. Okay, that's the first source. What about partners? Are partners the same? Are partners different as neighbors? So here we go to source number 5. Now we go back to the Jewish code of law. Choshen Mishpat 175.5. If one of the brothers, we often deal with brothers who inherit an estate. As long as they inherit an estate, they have not yet made a division of the estate, they're considered partners. So if one of the brothers or one of the partners sells his field to an unrelated party, the rest of the brothers or the partners can remove the buyer. Kick out the buyer and say, no, you don't get this, I get this because I have first dibs to it. Now, what is the relationship in terms of on the hierarchy? Who goes first? Let's say you have a partner who wants to buy it, and you have a neighbor who wants to buy it. So we go back now to source number 6, Aruch HaShulchan. A partner has a greater power than a neighbor when he is a partner in that property. How so? If brothers inherited a property or partners bought a property and one of them sold his share to someone else, even if that person is a neighbor, any one of the partners, even if there's many partners, any one of the partners can say, I'm a partner in this because not only I'm considered both a partner and a neighbor, because I own part of it, right? So therefore, I'm a neighbor, right? I own, call 33% of it. I own this 33%, so I'm next to it, and I'm a partner of yours. Therefore, partners take first dibs over neighbors. They have ultimate power, and it says here very carefully, and even if there were many partners and one of them sold his share, any one of the partners can go and demand first rights to it. So it would seem like Gary's clients are in good shape if they go to Jewish court, right? Because here we have a client who's a partner, and he's saying, hey, I get first rights. It's clear in Jewish law, right? Not so simple. Why not? Okay, because Gary mentioned something in the agreement before. Let's go through the wording very carefully, and this is where it's going to get exciting. What did it say about a sale?
It said about a sale that the manager was authorized to sell the property if he had a majority of the membership interest agreeing to the sale.
And he's got that. Now the question here, we have 2 questions. What happens when I have a document that stipulates something that might not be according to Jewish law? It's giving power, at least seemingly, to the majority shareholder to sell to anyone he wants, and that's not what Jewish law says. Jewish law says you have to sell it first to your partners. So how do we rule when Jewish law and your document don't agree? So if we look at the next source, and we got 3 more sources we'll do real quick, and then we'll get to a interesting conclusion. Anyone who makes a condition, says the Mishnah, there's a Mishnah in Baba Metzia 7:11, source number 7. Anyone who makes a condition that goes against what is written in the Torah, the condition is invalid. So I'll give you an example. Well, actually, Gary gave an example before. It's the same thing in American law. If I make I say I'll sell you this property for $1 million on the condition that you kill somebody, right? So the way it works, I don't know how it works in American law. Maybe the whole thing is void. Is that how it works in American law?
Void ab initio.
Okay, so in Jewish law, it doesn't work like that. If I sell you a property for $1 million on the condition that you kill somebody, so the property is actually sold, you just don't have to fulfill the condition. The condition is void. The deal is not void. Okay, so it might seem here that this guy, the majority shareholder, is saying I can sell it to whoever I want. I've got the document, but the document seems to go against Jewish law because Jewish law says it goes to the partner first. But it's also not so simple.
Nothing ever is.
Nothing ever is. Well, let's do another source here. Source number 8, Talmud Bavli, Bava Metzia 94a. For we learned in a brisa. Here we have an interesting case. A man gets married to a woman. And by biblical law, a man has certain responsibilities to his wife. The 3 primary responsibilities that he owes, that he's obligated to his wife are to care for her, give her food, make sure she has what to eat, make sure she's dressed, make sure to give her clothing, and to give her conjugal rights, to give her, to take care of her in that way. Now, what happens if someone gets married to a woman and says, I will marry you on the condition that you waive those rights? The Torah gives you a right that I have to support you and give you food and clothing and conjugal responsibilities. I don't want to do any of that. I want to just marry you. Does that marriage work? So here's the brisa. We learned in the brisa, one who says to a woman, I betroth you to me on the condition that I do not owe you food, clothing, and conjugal responsibilities. She is betrothed, and the conditions are invalid. These are the words of Rabbi Meir. Rabbi Yehuda disagrees. Rabbi Yehuda says, in matters of money, the condition stands. Which means that if I betroth the woman and say, I'm betrothing you on the condition that I don't owe you food, clothing, or conjugal responsibilities, in matters of food and clothing, which are financial responsibilities, the condition stands. Because it's considered as if I have the right to give away my money anytime I want. So it's like the woman just gave away. It's like she was mochel. She forgave that financial responsibility. But when it comes to the conjugal responsibilities, that's not a monetary thing, and that cannot be waived. Okay, how do we rule? Do we rule like Rabbi Yehuda, who says that in financial matters you can waive your Torah rights in any kind of form of document or agreement? Or do we rule like Rabbi Meir, who says even in financial instruments you cannot go against Torah law? And here is our last source for the night, Shulchan Aruch Even HaEzer. Even HaEzer is the section, until now we've been dealing with Choshen Mishpat, which is the area of Jewish law that primarily revolves around civil law. Now we're in Even HaEzer, which is the pillar of Jewish law that deals with family law. And it says, if he made a condition at the time of betrothal that he would not have responsibilities to her regarding food, clothing, the condition stands. And he does not owe them to her. However, if he made a condition that he does not have conjugal responsibilities to her, the condition is invalid and he owes it to her. Furthermore, Haggah, because anyone who makes a condition against what is written in the Torah and it is not a monetary issue, the condition is invalid. And there are those that say that anything decreed by the sages, it is as if it was written by the Torah. So, what is very clear here is, the way we rule in Jewish law is that you are allowed to make an agreement against Jewish law. So even though by Jewish law, a partner gets first dibs on a property, if you write into your document that a person does not get that right, he does not get it. And here's where the crux of the issue is. Go ahead.
So I take the position on behalf of my client that while it says in the agreement that the manager has the authority to sell if he has a majority of the member interest to do so, it also has a Beis-Din clause. And by putting in the Beis-Din clause and saying all disputes are going to be resolved in the Beis-Din, I would argue to the Beis Din, although I'm not the one doing it, okay, that by putting that clause in, that incorporates all the Jewish law, that there would be that right of first refusal. Now, the document doesn't specifically say there is no right of first refusal. There's not a meeting of the minds, I would argue, where the parties said, we agree that the right of first refusal and the neighbors doesn't apply. All it says is the manager has the authority to sell if you have a majority of the members. I would argue, but by incorporating the Beis Din, it also means unless you're selling it to a partner under a right of first refusal.
Well, this is similar to an arbitration clause. I mean,
This is an arbitration
well,
clause.
yes, and you would be bound by it, and wouldn't even have the right to appeal it to a court, unless they severely abuse their discretion. So.
The question
The
is,
question is, from a legal point of view, how is this different? I mean, what's the issue?
if you were the Beis Din,
Yeah.
how would you rule?
So here's the thing, though. Let me just.
But that's separate. The first issue is, do they have to go to Beis Din? The answer is yes.
Yes.
It's like writing an arbitration clause in there, so.
No
they'll
dispute
decide-
there.
So they'll decide if at the beginning of the contract, there was a meeting of the minds or not with respect to Mr. 66%.
Right?
So everyone agrees they're going to have to go to Jewish court, because that is the clause in the document, that when there's a dispute, they have to take it to a Jewish court. What Gary here is saying is more than that. He's saying that because they wrote a Jewish court clause into the document, they were implying that when there's areas that are not specified, that it would revert to Jewish law. However, I would say, no. It says you take it to a Jewish court of law. A Jewish court of law would tell you that you are allowed to circumvent Jewish law by writing a document that says that we're not going to follow Jewish law here. And if they wrote a document that says that the majority shareholder can sell it without qualifying it according to the first of rights of refusal that are normally part of Jewish law, that was their bad. They missed out on that chance, and they lost that opportunity. So yeah, you could take it to a Jewish court, but a Jewish court would say, listen, our hands are tied because you wrote the document. You should not have given that power away freely in the document. We have a rule in Jewish law that if you have a condition that goes against the Torah in a monetary case, the condition is valid.
No, because that's voiding the clause going back to that, that's voiding the clause that says we're going to take it to a Beis Din. Just like if you have an arbitration clause, you will follow the rules. Let's say you say it's an arbitration clause, and they're going to follow I don't use arbitration, but because in family law, it's suicidal to do that, I think. But you'll follow the American arbitration, rules and stuff like that. That's assumed, and you're going to follow their rules, even if the circuit court would have decided differently. If you decide you're going to go according to the laws of Delaware, then yeah, you're out of luck here in Michigan if you wanted to use more favorable Michigan laws because you chose, usually it's the other way around, because you chose to, use the Delaware or incorporate in Delaware. So I'm thinking that if you put a clause in there was a meeting of the minds that you're gonna follow what Beis Din has to say.
But what makes it a horse race is the arbitration clause that you just described says we're gonna take it to arbitration and it's gonna be decided under the laws of Michigan, okay? My Beis Din clause in this case doesn't say that. It doesn't say it's going to follow Jewish law in the Beis Din. It just says it shall be decided by the Beis Din. Because you got two Orthodox Jews on either side. How can they not? They have to take it to the Beis Din.
And more than that, by the way, when they take it to a Beis Din, the Beis Din is bound by that document because the document of the contract says, whatever it says, even if it goes against normative Jewish law, when it comes to financial areas, you are allowed to make agreements that go against normal Jewish law, and Jewish law is to follow those.
But because there was a meeting of the minds to go to Beis Din, that to me looks like source number 1 in Exodus 21:1. And these Elah Mishpatim Asher Tastim Lifneim. These are the statutes you'll place before them. That means, according to my humble opinion, that when you put that clause in there and you specified a Beis Din and not the American Arbitration Agreement, it wasn't just, well, we're both Orthodox Jews, so let's put something in there that has no meaning whatsoever. It's because that's the way we're going to go, because that was your source number 1 that opened the other 7 sources,
Okay.
they're gonna follow that.
I'll tell you what, let's just make it very, let's do this very, we'll make it more clear, because there's a litwill bit of ambiguity, which is the final sort of piece of it here. It said that the majority shareholders have a right to decide to sell it. Gary's client's not disagreeing. He says, you have a right to sell it. He's just saying, but now that you have a right to sell it, I get first dibs, because of Jewish law. Which they would disagree with. They would say, we have the right to sell it, it's unqualified. However, one thing for sure, if they had written in the document, for sure, had they written that the majority shareholder has the right to sell it to anyone he desires, then for sure, Gary's client would have absolutely no teeth here. Nothing. Because the Jewish law is that you follow the document. And the document says they can sell it to whoever they want. But it doesn't say that. It just says that the majority shareholder has the right to sell it. It's an unqualified statement. And that's kind of where it becomes very, very murky. Because it's unqualified, so do you say it means he has the right to sell it, period? That's all the rights that you've given him. And therefore he has the right to sell it, but he has to afterwards follow Jewish law and give it to the partner first? Or do you say it's an unqualified statement and therefore he can sell it to whoever he wants? We don't know the answer, by the way. Neither of us know the answer. And the Beis Din will have to ultimately settle this one. It'll be fascinating to know, and that's sort of where the Beis Din comes in.
But before I take that, I will tell you that under secular law, and this is why there's the conflict with the Beis Din, or if not a conflict, an interaction, under secular law, it's clearly my guy's out of luck. Okay? No chance whatsoever. The document clearly says that the manager has the right to sell it and the authority to sell it so long as he has a majority interest. No right whatsoever.
That's true.
But by incorporating the Beis Din clause, now my client has potential. So now you see that you may get different results under the secular courts versus the Jewish
Yeah, your
courts.
guy has a fiduciary, she's right, your guy has a fiduciary responsibility, the other 33%. So whatever went on in that other component with the receiver, he still can't arrange something that specifically, they use the word, screws over the 33% guys. I think I agree with her.
I hear that.
He has a fiduciary obligation even according to secular law.
And we've dealt with, that is an issue we have considered, okay? And that is an issue that we are raising with the secular court, okay? We're trying to stop the receiver from selling the property. And we're arguing it's because this guy has dual interests, okay?
It's also
But-
becomes fraudulent,
but-
because he said a random price so that he could make the money on the business and avoid and minimize the amount he has to pay his partner by setting the false low price.
Now, in fairness, that's my client's position, okay? The other side doesn't agree with that. Okay, the other guy isn't like admitting, you're right, I'm doing this to screw you,
No, he
okay?
didn't want to screw him. Because he has a fiduciary obligation irrespective of what his own personal thing is in the other component.
And he's arguing, so and we're getting into a lot of detail,
Can
which
we go
any,
on
you
to
get
something?
room full of lawyers are gonna do, okay? He's arguing he is fulfilling that fiduciary obligation, okay? Because if you don't tie the real estate to the operating assets, no one will buy it, okay?
Can we go
And
on to
he's
something else?
saying, I've got it figured out, I'm acting in your best interest, because if I don't include the real estate with the OpCo assets, you'll get nothing for your real estate. Because the business will go under and your real estate will be worthless because there's no business operating on it. So he's arguing factually, he's not doing the bad stuff that we're saying he is.
So in secular.
And he's working on the case, so
Yeah,
this is my partner, Steve Hurwitz.
So in secular court, there's a belief that real estate, it's interesting that this is a real estate deal, right? Because in secular court, real estate is considered unique, and you can get injunctions to prevent the sale of real estate because it's deemed that there is no monetary value that can sell a unique asset.
There you go.
Would there be anything that could be done in the Beis Din here to argue that this isn't really, because it's real estate, it's unique, and monetary isn't going to save it, and therefore this isn't a monetary thing that would get you out of the Jewish law?
So it's actually interesting you brought that up, because there is a specific unique clause to real estate transactions as far as Jewish law. And that is that when it comes to normal, we call movable property, right? In Hebrew it's called metaltalin. So there's a rule called ona'ah, which means it's the law of like I'm almost paining you or damaging you by charging you too much. So for example, if you're an unsuspecting guy and you come into my store and I've got a diamond ring and I say, this diamond ring is worth $50,000, whatever it is, and I sell it to you for $50,000, and you get it appraised and it's worth $4,000, you actually can void the sale by Jewish law. However, specifically when it comes to real estate, there's a rule called ein ona'ah l'karkos, which means there is no overcharging or undercharging when it comes to property. Because it's a real estate asset, people value it differently, and there is no specific way to peg a price to real estate specifically. And therefore, you don't have overcharging or undercharging. Yeah.
Let the buyer beware.
Let the buyer beware. When you're buying real estate, let the buyer beware, because it's real, and you can't later claim, well, I thought it was worth this, I thought it was worth that, which you could do when it comes to move. You sell a guy a watch or a diamond ring or whatever it is, a car, anything other than real estate, you've got some kind of price control in there, which you don't have when it comes to real estate.
You can say that if I buy, the two Jews can contract to say, we're gonna follow secular law, and the Beis Din follows that.
No. No, that was the third source we read. That Jews are not allowed to write, we are agreeing to go to a secular court
No,
to
that's
settle.
not what he
That's a
said.
secular court.
Oh, you're saying to contract that they will follow secular law in a specific area, yes.
What's the difference? Like, they can contract, they can do this, but then it's based in permission.
Right. So it's actually a very good question. So meaning, the language of the contract would not be that we agree to follow secular law in all matters in our contract. That would not be the clause you could put in. However, you could delineate any specific secular law that you want to follow and agree to follow it.
So-
Except that I'll sue you.
No.
Secular court.
Right, exactly. Now, for example, like they could have written in the document, for sure, the majority has the right to sell it to anybody they want and has no rights of first refusal to other partners. And that's it. That's all they have to write. If they wrote that, there would not be a Beis Din case here. They didn't write that. That's why there's a Beis Din case.
But Gary, are these partnerships, real estate partnerships, very common, where there's a majority partnership that controls it? And it's a very common partnership setup.
Yes.
Okay.
I'm just curious. You said you couldn't argue the case at the Beis Din. Who can argue case at the Beis Din?
I didn't say I couldn't, I said I'm not. And if I said I couldn't, it meant because I wasn't skilled in the arguments to do it.
Right.
But you can address the issue of lawyers at Beis Din. I think I know the answer, but you'll know better than me.
So it's like this. Gary spent a lot of time studying American law. He went to an American law school. Right? So if he would try to go into a Jewish court, he'd be a fish out of water. There are people who spend their lives studying Choshen Mishpat, studying the laws of Shulchan Aruch, the Jewish code of law, and they're often called to'anim, which means they are case presenters, basically, and they present on your behalf in a Jewish court of law. Here's the thing, it's right now 7:30. I want to be timely, so we officially are done. We'll stand here if you guys want to come up, anyone wants to come up and ask questions, but we want to just thank you so much. It's a real pleasure doing this. So, thank you all for